in head ramps. I don't want a mic. We are in the PED ramps, session 110, and George Lukes will be starting out. I'll give a little background on the court case, and then George will take us home. Hopefully we won't take quite the entire hour, so we can get you out a little bit early here. But with that, we got George Lukes, who is the pre-construction engineer for the department, and I'm John Leonard. I'm out of Traffic and Safety and Operations. ADA is now falling under our groups, and so between design exceptions and how we're going to put it together and how we're going to do training as well. So we just thought we'd give you a little background of what's going on here.
Thanks, John. Like John said, this is, I know everyone's going to be very disappointed, but this is probably not going to go anywhere near the hour. So you're going to get out a little early. I know John's really upset about that. So I'm going to go with a little bit of background of why it's an issue. This is about probably 2 years ago. We started having problems. Well, I shouldn't say we started having problems, but we got a lot of information from the regions that Federal Highways was coming out. They're looking at ramps. They're saying that they're out of spec, and these are ramps that have been in service for 15, 20 years even, maybe 10 years. And in essence, So Lisa Wilson was getting these calls, and she wanted to know kind of what were all of the field issues with these, and specifically the PED ramps. Can everyone hear me okay? No. Okay. Oh, great. Okay. So kind of one of the other things that happened was we started getting calls from pre-construction engineers saying, hey, we're going to have to go out and rip out these ramps that have been sitting here. What's the problem? And so the next thing we started doing was looking at why we do them. This goes back about 20 years. We've been doing them. And one misconception coming back to Federal Highways, having us rip them out, is that they are the authority on this. It really is not Federal Highways, it's the Department of Justice. And Federal Highways is acting in their behalf, sort of like we do on local government projects. So this is not something that they're doing. This is more of Department of Justice. It's the overall ADA compliance, which is not just roads, but it's buildings and everything else that goes along with it. So, in fact, you know what? This is where John's going to talk a little bit about our history and the court cases that we've been in, and then I'll kind of go into where we've been and where we're going with this.
So one of the things that we've really got going on the ADA is it's been the law of the land for, like George says, well over 20 years. Unfortunately, we didn't really comply with it for about 10 or 12 of those years until the middle 2000s. And part of that was the requirement is there, and as George says, it's the Department of Justice is the one that enforces this. It's not the Federal Highway, it's not Roland coming in to beat us up. These guys come in and they play hardball. And so it's the ADA Act of 1990, it's a statute in federal code that prohibits discrimination against persons with disabilities, no matter what they happen to be. And so as part of that, the pedestrian ramps come into play, which is what we're primarily dealing with. And that's one of the things that UDOT, we comply with very well now, but historically we did not comply with it as well as we should have been. And one of the reasons that was doing that is we were talking about what triggered when we had to go in and do ramps. If there wasn't a ramp there, there was a substandard ramp. Well, typically UDOT said, if it isn't a blue book, we don't have to do anything with it. And so these individuals, Decker, came in and sued the department saying that our definition of alteration, which was we got to have a full project where we're removing everything, ripping it out and starting from scratch, was not necessarily the correct interpretation, and that we should be doing these on a much lesser scale. And they were even saying that if we were doing a microsurface, that we should be coming in and changing all of the ramps. And so ultimately they sued us. They came in, they challenged what the definition was, and they said, ultimately we came to a stipulation that new construction must comply with all current ADA requirements, and then alterations must comply to the maximum degree of feasibility. So then we had to decide and determine what the definition of alterations was. And that came out of a stipulation in the court case, because the majority of our roads have ramps on them already. They may not be perfect, but there's some kind of ramps out there. You know, they just sloped them down, they stamped them with a concrete stamp and called them good. So the majority of the ramps that we have out there really fall into that alteration category, not the new construction category. So basically we said that if it was considered an alteration, then we'll upgrade all non-compliant existing pedestrian access ramps as part of the project. That was a little bit about what George was talking about, is that if we'd done them 5 years ago and we didn't document them well, or there was something wrong with them, we didn't build them correctly, we were ripping them out again. So we were ripping out a lot of brand new ramps that were going out there too. So basically construction, reconstruction, and maintenance. So what is an alteration that requires ramps to be done? Whoa. Essentially, if it's very minor, if it's like just rough figures, if it's about 1 inch or less on the facility, so if we're doing things like crack filling, surface, slurry seals, fog seals, crack seals, a dowel bar retrofit, things that basically aren't really affecting the roadway surface, then that's considered a non-alteration. That is a maintenance activity, and it does not require anything to be done. However, if we're starting to put open graded surface cores, cape seals, which we don't really do, mill and fills, in-place recycling, if we come and put an overlay, any of those is considered more than routine maintenance, and that will trigger an alteration. So that was what we came to the agreement and the stipulation as we settled this court case. So basically, starting in 2006, we started an inventory of all the intersections on state roads. There's some people in here that were actually doing that as a seasonal. And so we did about 9,000 intersection corners. They were all documented with GPS. They measured all the grades, they measured the widths, took pictures. Everything was documented on these. And so then when we had that, then we looked at where we were going to have projects. And so we tried to include those that were not standard in those. And if they weren't, we created new projects for them that we went out and did. And as part of this stipulated agreement, the Transportation Commission allocated $1 million a year for 10 years. In other words, $10 million to do nothing but pedestrian ramps. And so this has essentially been accomplished. There's a list of them. It's actually on the website. Sharisa Olson is the one who takes care of that for us. But I don't know, there's maybe 200, 250 statewide that are identified as not being done yet, but they'll be done when there's a project or the ability to come in there. So anyway, we maintain that inventory. It's maintained in traffic and safety. It's geolocated. And then, if we receive a complaint, could be through a citizen, could be through a city, county, we'll go out and look at it. And if it's something that needs to be done, we'll take care of it. We'll find the state safety funds to do it. So, anyway.
Thanks, John. And stay away from the speaker, right? So,
This speaker, not that speaker.
So John's kind of giving you a history of what happened that got us to the point where we're replacing all our ADA ramps. But what's happened is since then, that right here? Since then, we've had the issues that we've also come up with having to pull them out. And so what was asked is to form a committee and try and figure out, first of all, what the issues are and how we're going to address it. So it's taken a really long time. And the committee was formed of both central and region personnel. It was John, myself, Lee Simmons, Jeff Lewis, Chris Potter. At the time, he wasn't the local government, he was in a different position. Fred Daring, Griffin Harris of Region 3, PJ Rubinet, Stan Adams, Dave Adamson, Devin Monroe, Josh Van Jura, and Roland. And we basically got together and started hammering out, what are the issues that have been going on and what ramps have had to be pulled out and what happened with those. So some of the issues that were identified, Construction was saying the standard drawings are challenging. You know, they get out there, they're on one sheet, the notes refer to another sheet, they're not quite sure what needs to be done, and that there probably needs to be a redo of the standard drawings. There was a huge uncertainty of what technically infeasible means, and when that can be applied, and when it should be applied. Orange Book and Purple Book. When we need to do it on that, we don't have survey, so how do we do it? Project teams were not sure whether ped ramps needed to be addressed. Like John was saying, you know, it's got to be addressed on projects that don't have alterations. It's got to be addressed on other projects. So there was a lot of uncertainty. The guidance document was issued in 2005. Larry Montoya, I think, was in charge of this. He went to put it together. It was actually a very good document, but I don't think that many people knew that it existed except the form that's filled out in construction. So it was people not knowing what the guidance should be with it. There was a lack of design support in construction. What I mean specifically is we get out there and standard drawings don't apply, and it's in construction, and the guys in construction don't know what to do, so they do the best they can with what they have. I think one of the ones we were looking at was in, I want to say it was Price, and there were a huge number of ped ramps that needed to be done. And it seems like it was Leif Condi was the RE, and he said, look, this is really good for a lot of them, but there's some that don't fit this, and we need to have a plan sheet for it. So there's a lot of different issues like that. One of the bigger issues in the field was that the Federal Highways field engineers would come, and they're using a different tool than we're using. And so they may show a cross slope that's different than what we showed on the form, and that became an issue. Measurements and requirements that were recorded to be within the guidelines then were not accepted. So we're having a lot of these issues in the field, and those were the things we identified up front as things that were recurring and things that we might be able to address. So there was a lot of recommendations that came out of this. One was, let's revise the standard drawings, make it, and I don't know if this has gotten to that point yet, John, where the notes are separate and they're on one page that apply to all of them. Yeah, this is going to be the 2017 standards, right? Yeah. So those are the kind of things that will be really useful once we get those in place. The second recommendation was that there is a training or a certification program that's developed. And basically what this is something that says you understand what's supposed to be done so that when you get out in the field you can kind of identify that stuff. Define what technically infeasible means in the guidance document so that everyone's on the same page. Use GIS technology so that if you're in the field, you have the ability to see if that ramp was constructed the way it was intended to be. And then partner with Federal Highways to establish an agreement so that we can have a path forward and understand where we're coming from. So this committee then, we took these recommendations to Lisa Wilson, Randy Park, and said, is this the direction we ought to go? And they supported and said, yeah, this I think is going to make things a lot easier. We talked with Roland, we talked with Russ Robertson, and I think Dave Cox was also involved. And we, in essence, said, yeah, this is the right direction to go so that we can try and reduce the number of issues that we have in construction. So the first thing that we agreed to do was kind of look at the guidance document and see what changes needed to be made. The first decision was that if there's 10 people looking at this guidance document, it's probably going to take 3 years for it to get taken care of. So we gave it to a couple of rotationals. I think one was Cody Raymond in Region 2. He'd been doing a lot of ped ramp stuff. He took a look at it, and we kind of looked at it too, and it turned out the document's actually pretty good, and there were very few changes that were made to it. Jessica Andrews had come up from maintenance at the complex, and she started taking all of the comments, putting them together, updating it, and getting it to a final form. The field form that's in the back of the document, which is what's used for documentation, that also was modified. And that original document now has been replaced, and it's on the web if you do a search for it. So the next thing we did was talked with Roland and Russ and Dave and tried to agree some of the things that we can do to make things more consistent. The biggest thing was probably consistent measuring tools, making sure that we're on the same page of how we're going to do it and what we're going to use. A certification program. This is in essence going to a training program and then having a certification at the end that you've been through that program. Contractor personnel that are certified have to be on site anytime ped ramps are being constructed. Contractor and UDOT certified personnel will sign the form saying that those are the measurements or the things that they've looked at and are accurate. And that REs will notify the area engineers prior to the project, basically saying, here are the ped ramps that are on the project, here's our rough schedule, here's how we expect to take care of them. And that we'll use the signed form to help resolve any out-of-spec issues. So if we do come back in 2 years, what we're going to be looking at is that certified personnel actually did this, they've got the numbers, and that will hopefully help to reduce the issues that we've had. So what happened was in June of this year, we came to an agreement with Federal Highways and basically have a memorandum of understanding that takes all of this into account. The MOU establishes a couple of specific things. One of them is that we'll develop and we will administer a guidance, or excuse me, a training or certification program. What that's going to be is it's going to be for anyone that's going to sign the form. Likely it's going to be REs and contractor representatives, but there's still, the likelihood is that district engineers are going to require it for all construction personnel, for that matter, to go through it and make sure that they understand what needs to be done. Correct installation, that everyone understands what the guidance is and how it's supposed to be installed, that there are correct acceptance criteria, and that the process set forth for technical and feasibility is followed. So that's actually in the guidance document, but it's a policy and it's got a specific definition. Part of where I think it falls short just a little bit is one of the federal documents says that it's a percentage of construction. And that makes it a solid thing that would say, here's a dollar value that if you have to go more or you have to go above that, that you would do it. So an example would be if you're in downtown Salt Lake City and you've got a sidewalk that may not fit a ped ramp, theoretically you can make it meet the standard. It just might cost billions of dollars. So if you had a dollar value you say you would not go above, that would make it technically infeasible. Another thing that we talked about was there may be a misconception that if it's technically infeasible, you don't have to address it. It doesn't mean you don't have to address it, it just means that you may not make it to standard. You still have to make the best design you can, but it's just not going to meet the standard as it is. And so Federal Highways agree, one last thing, that the UDOT REs notify the area engineers so that they have the opportunity to come out and inspect if they have the time and they're in the vicinity and such. That way they know what we're doing, they can come out and look at any time, and hopefully if there is an issue, it's taken care of at the construction stage and not a year or two later. So that agreement of UDOT acceptance of ramps is not something that Federal Highways is willing to say that they're not going to ever come back and make us do something different based on what the DOJ says, but it's that it's a certification that we followed our process. So now we're at the stage of this training and certification. And Lori Economy took the lead role initially in the training development, and we kind of identified what our desired outcomes would be for this. The first thing is education for contractors. Make sure they understand what needs to be done on these ped ramps. Education for our UDOT construction folks, same thing. Making sure they understand what we need. Education for pre-construction, that they understand kind of in this technical and feasibility what needs to be done and what the definition is and what needs to be done after that. One of the things that we've developed is something that's going to be basically the same process as design exceptions, but it will be for ped ramps. If there is a technically infeasibility determination, it would go through that same process. We haven't come to a determination of whether it will be like deviations, where it ends with the pre-construction engineer, or if it's like exceptions where it comes to central, and I think the likelihood is that's what it's going to be, but that will be the process. The form has not been completed yet, but it'll be something similar where you would say what your design is going to be so that it meets technically and feasibility and you're best constructed or not. but that's where we'll go with technically infeasible. Proper filling out of the form, what needs to be done, how it should be filled out, and field demonstrations, process resolution of issues. At the end of the training, there would be a certificate. The certificate will be signed by the person who does the training. We expect to have a GIS interface with this so that it can be retrievable. And that, again, the technical infeasibility exception is actually defined. And the requirement is, if you're going to do a UDOT job, you have to have the certification. At least the person that's on the job doing it has to be there. So this training is going to begin in early 2016. I think right now it's slated to begin in January. Russ Scoville is the state head ramp coordinator. He's going to be coordinating all this and putting it together and probably leading that entire discussion on the training. Winston Inouye is the training coordinator that's going to be doing it from Glory Economy's side. And the training is a combination of classroom and field, and the schedule for the training is going to be released soon. So I'm going to go back a step on this. With this training implementation, the GIS, what the expectation is that we go out, we construct the pad ramp, the contractor puts down, let's say for cross slope, what their measurement is, it's 1.9. The UDOT RE or field engineer goes out, puts down what theirs is, and signs it. That form is then taken, I think what John had said, to Sharissa Woods. She puts it into GIS, and now that's also linked to the certificate that's in Mike Garcia's training database. So now if you're out in the field and there's a problem or a perceived problem with the ped ramp, you're able to pull up on GIS, pull up the certificate, look and see and say, when this was measured, when it was constructed, it was fine. And so if there is a measurement of 2.1, then the discussion becomes a little bit easier that at least in the process of doing it, you had 2 signatures and 2 certified or trained people that have done this. This is what we're hoping will reduce the issues that we have in the field. So hopefully this GIS interface will make it so that we have all of the information with the certified trainers, or excuse me, the certified individuals who have signed it, and a link to their certification. So with that, any questions? Yeah.
Will consultants need to have this certification?
Excuse me.
Will consultants need to have this certification?
So the question is, will consultants need to have the certification? Consultants will have to have the certification if they're going to sign the form. So there's still a little bit of, so a lot of times what we do is we say that the resident engineer will delegate that task to someone else, but someone who has the certification will still have to sign it. So an RE may sign it on behalf of their field engineer or TransTech or someone who's gone out and done the measurements. I think that ultimately district engineers may require anyone that's going to do that work and is going to be doing the measurements will also have to be certified and sign it themselves. Yep, just 1 second. So question is there any changes that may come that would affect this, right? I don't know how to answer that other than it could happen at any time. And Roland's got an answer for this.
The access board right now is got.
The standards we're using are the proposed changes. They have been proposed changes since July 2011. Typically, the government takes a long time, but typically it's less than 4 years. The last thing I heard was that they were going to finalize it first part of next year. I wouldn't expect a lot of changes from what's proposed, but there could be.
So Roland said the first part of the year, but he just assumed it was next year, right? All right, you had a question? So you still have to do the forms. They still have to be filled out. but the certification on those will be basically for next construction season. So there will become a point in time where, since we haven't had the training yet, we can't have it on those projects. But once the training begins, and we're going to have a little bit of issue with projects that go out and there hasn't been enough opportunity for people to do the training, so that's going to be a work in progress. I think what we've been talking about today is going to be something that once we get into a point where we've been down 6 months or whatever, where there's been an opportunity, it will be on all projects that it's done. I think that other projects, it'll probably be a special provision that will say you've got to be trained and certified to do it. Yes? I'm going to try and stay away from the speaker.
An issue has kind of come up in Region 2 recently, where now we've begun to consider dead button part of the head ramp. You know if that is the case, the Congress is going to consider that since you go out there, that button is not feet at the top, back, top back. Now that's got to be done for head ramp itself to be part of the lawsuit to be standard.
Okay, so the question was for head ramp button placement, right? And there's a standard for it, and would you have to rip it out in essence to go back, right?
Well, I do lots of reviews, and this has come up. We had buttons that
Right. So let me answer that from kind of what the question's been. I'm going to get away from the speaker. Where the question's been in the past, which is exactly what you're asking. What we're hoping to do is get to the point where now we'll have documentation of why it was done that way, and there will be an exception form that's signed that said we couldn't build it to standard, here's how we built it, and here's why it was done that way. So for the past ones, yeah, we're still going to have to consider it and figure out if it's something that has to be redone or not. If it can be built to standard and it wasn't done before, then the likelihood is it's going to have to be redone.
That button, even as far as, like right now, Purple Book, you say I've got headrooms that are out, and you start listing, like, well, you submitted these ones and you feel are out, but you still need to check them all to make sure the back that's not type of thing. Head buttons are a whole different beast. That now falls into certain diagrams and certain things, etc. as far as signal sheets.
Right.
So I guess what I'm asking now is, I don't know, maybe I just missed it. Are we going to consider the pen button part of the head ramp?
It's part of ADA.
If it's part of the ADA, absolutely. Yeah. Uh-huh.
As a consultant, when we're doing a project, we go out and determine how many of the head ramps need to be reconstructed. And oftentimes we compare that to the GPS log. And the log shows the capacity of their head ramp that's showing fails. Is that common? And if so, what do you want us to do with this?
So which shows that it passes? I'm sorry?
The GPS log,
Okay. And what shows it fails?
our visuals.
So again, this is going to kind of get into that gray area. In the past, we don't have the documentation of what it was. So there may be a log that shows that it was done a certain way. But we don't know if the person was trained properly. We don't know if they did the measurement properly. We just don't know. We hope that it was done right. So going forward, we'll have that documentation. So for right now, I think that the reality is if it's not in spec, then that's a discussion that you have to have probably with the design squad manager and the region pre-construction engineer. And if it needs to go further, we'll probably go to John and myself, and we'll probably talk to Federal Highways to figure out what we need to do with it. I don't know, it's kind of a case-by-case basis to figure out what needs to be done with it. The challenge is that some of the things are you cannot exceed, period. Cross slope, it can't be more than 2%, period. But with that said, we also don't want to be in a position where it was measured and it was 1.8 and 1.95 and we've got all the documentation, and someone who has a disability would be looking at us and going, why are you guys replacing that ramp? type thing. So that's why the documentation will help, but for now, we just have to have a discussion and figure out what needs to be done. For this? You know what, it's historical. I don't know what it is. Do you know? No, he's just, this is a curiosity, right? Yeah. So technically infeasible, that's what I was saying earlier, is there was a document we saw where it put it as percentage of construction.
That
But
does not apply to public right away. Period.
so that's what I was saying, is technically infeasible does not have a concrete value, but it should.
It's not going to happen.
Right, and so then it becomes a difference of opinion of what, we have the technically infeasibility definition in our policy, and that's what we're using. And so instead of it being a hard dollar value, now it becomes a judgment value. So there still is going to be that problem with the judgment. Yep.
Is there ever a chance we're going to have this much emphasis on the sidewalks and we have these pet ramps, or we just only care about pet ramps?
So
Because if we only care about it because legally we only have to care about it.
no, I think we all care about it, and you know what it becomes an issue of realistically is if you have project dollars, and the project dollars for us we're different. We don't have the majority of our money coming from the feds. We have a fairly good percentage coming from state dollars. But most states have to look at it and decide where should their safety money go? Where should ADA money go? It's required to have ped ramps, but it's not required to have sidewalks. So is it safer to address your sidewalks than to address something else? So it becomes a balance, and it's a hard decision. You know, how do you decide which one to address first?
Well, so there's a section of 700 East between 39 South, 33rd, and there's literally, okay. So there's a section of 700 East between 33rd and 39th that has directional ped ramps, and there's literally no sidewalk. This is a ped ramp to nowhere. This is a section that was roto-milled a couple years ago, and so why would we be putting in ped ramps to sidewalks that aren't there? Like, we're literally putting in ped ramps to nowhere, but we're putting them in because federal government says we have to put in ped ramps. But when are we going to be concerned about where these ped ramps are going and who and what they're accessing? Is it going to take a lawsuit until... And here, this is a case, I've had this conversation with a couple people. It's UDOT right away, but I've been told that it's the county's job to put it in, or the city's job. But then the county says, well, it's UDOT's right away, so UDOT's supposed to do it. So then at what point do we put in sidewalk?
So it's a great question. I wish I had a good answer for it. I don't. We also have that same issue in rural Utah where there aren't any sidewalks, and we put in a ped ramp. And so it's almost like we're not caring about the sidewalk, but we're putting in a ped ramp. I'm not sure I know the answer to that.
So if you're in a wheelchair, you go from one corner to the other. The corner you're going to does not have sidewalks, but it has a ramp. That's a little refuge area if you want to cross another leg of the road. So the ped ramp to nowhere still has value because you have no place for the wheelchair to be out of the behind the curve.
Totally understand that, but I think the question is different. I think
that's one reason why we would have one to nowhere.
right, but if I'm not mistaken, I think the question is, why aren't we putting sidewalks in? Is that right? Yeah, so the question is not, why are we putting the ped ramps in? The question is, we're putting ped ramps in, we're spending the money, why aren't we putting sidewalks in too? Is that fair to say?
That's not typically a UDOT function unless it's a project.
Yeah. Ped ramps, curb cuts is what I would use, are not required if there's no sidewalk, except if you got a push button. You don't have to build a ped ramp to nowhere. It's in your manual. That's what the federal requirements are. If there's no sidewalk, you don't need a ped ramp. But the other case is if there's push buttons for signal light, for signal, then you need the ramp up to the push buttons. And that's all you need. To your question, yeah, typically, unless it's in your project, as Doug says, UDOT usually says that the sidewalk is the responsibility of the local government. Federal Highway, we encourage to have sidewalks on all sides of all streets in all federal projects. It's not a requirement, but it's a strong recommendation. So, yeah, I thought you were talking about when you have a sidewalk, but it's not in conformance with the ADA. That is a similar issue. That's a similar issue, and if it's not in your project, if the sidewalk is not in your project, then you don't have to do it. But UDOT should inform the local when you're doing the project that it's out of compliance, and they should put it in their transition plan.
I'm pretty sure we did not answer that question. And I'm sorry about that. I think there's a lot of different scenarios that come up, and I think the one you're talking about is much more of who owns it, who should be doing it. And I think I don't know this for sure, but my guess is it's spelled out. And it's just a matter of finding out how to address it. But if there's not a sidewalk, sometimes there's other reasons why there's not. I mean, clearly, 7th East from 33rd to 39th should probably have a sidewalk, is my guess. And why it's not there, I don't know the answer on that. Any other questions? Yeah, Ann? If the standard changed. So the question is, if you have a ped ramp that was built to standard some years ago, the standard changed, yeah, do you have to then redo it? I don't know. Do you know, John? If a ped ramp was built to standard 2 years ago, now the standard's changed and you come back on a project, do you then have to bring it to standard?
The standards have changed, but if the standards have not changed,
so
if we're doing an alteration that creates a trigger that we have to do it, then we have to bring it up to current standards. However, if it was done 5 years ago under the same standards, that isn't a trigger that we have to go in and do it again, because if it met the standards and it was certified as such, then it can stay in place. So if the standards have changed and the trigger is there, then we have to meet the current standards as part of the project, or as best as we can. Any other questions? We'll let you go. No? One more.
So will designers have to get this certification that construction's going to have?
We definitely, sorry, there's vermin. We definitely want you to get the training so that you can understand it. The certification may be optional at the designer level, but for the people that are actually going to be doing the measurements and signing off in the field, both the contractor and the UDOT representative, it will be required for those individuals to be certified. But we want, as Russ rolls out this training, it will be very highly recommended that the designers take it as well.
So there's going to be a design element involved with it, and specifically it's going to be it's going to be for technical infeasibility and such, because there's going to be a need to know how to design them when they don't meet standard. So right now it's not a requirement, but the likelihood is if you're designing a project and it goes through that exception process, it's going to get kicked back to you if you don't understand what you're supposed to do. So it's highly encouraged that you take that training.
George, what John said I thought was very key to answering Ann's question about if 5 years ago it was constructed to standard and certified, that we don't have to change it. What documentation, I don't know the answer to this, what documentation do we have, or is this going to start that certification?
Yeah, so let me see if I got this right. If it was done 5 years ago to standard and we come back, and we think it was done to standard, right? And we come back and we do some measurements and it shows that it's out of standard.
Somebody else says, yeah, this
Right.
is that 2.1 instead of 1.9.
Correct. So unfortunately, I don't know how to answer
So we
that.
don't really have that
What we're
option.
trying to do is from here forward to try and reduce that risk. That way we'll have the documentation. And frankly, while we may not have the certification to go along with it, Sharisa has put a lot of that stuff into GIS, and you can still go and see those forms.
We had forms that should have been filled out on all of the ones for the last few years.
Right.
So if we can obtain those forms, so that's something that
It-
in design in
it's
terms
helpful.
of reviewing those, because I think we're chasing these over and over
Yeah.
and over again.
And like I said, this is what this entire effort was, is to try and keep it so at least from this point forward, we'll have that documentation and be able to see it. In the past, whatever we have is going to be helpful, but it's not going to be from someone that's been trained. You may not have two different measurements on there. There's going to be a lot of issues that already exist, unfortunately. Any other questions?
Make sure they sign the roster.
Yeah. Did everyone sign? Did anyone sign for that matter?
It's been going around.
Okay. Someone have the roster there? Oh, Becky's got it? Okay. Make sure you sign it. If it hasn't gotten to you, we'll have it up front to sign. If you need CEUs, come up here and we'll sign those as well. And any others? All right. Thank you very much.